I just wanted to welcome everyone. This is our third annual Currie lecture, and as most of you know, BrainerdCurrie really, I'd say, the dominant figure in conflicts, certainly in the last 50 years. We have the nice history of having had him as an undergraduate at Mercer, as a law student at Mercer, and then his first teaching position was at Mercer before he moved on to the University of Chicago and later Duke. But we have this lecture series in his honor, and we have Professor Kermit Roosevelt from the University of Pennsylvania, who is making Currie's contribution to choice of law, sort of the centerpiece of his talk today. Professor Roosevelt is a graduate of Harvard College and Yale Law School, clerk for Justice Souter on the Supreme Court, and has been teaching at the University of Pennsylvania. He's the co-author of a leading conflicts casebook, of a treatise in conflict. In his spare time, he also has a national reputation as a constitutional law scholar. So I'm very pleased to present him today.
Thank you so much. It's a great honor and a pleasure to be here. I'm a huge fan of BrainerdCurrie. And what I want to talk about in this lecture is Currie's contribution to choice of law. So there's a historical reason for that, which is that Currie, as your dean said, is an enormously important figure in the field, and there's a value to understanding what he said and what it meant. But there's also a more practical reason that I want to talk about this, for those of you who are interested in sort of the state of choice of law, because I'm going to argue, or at least I'm going to try to suggest, that Currie's basic insight can answer some questions in choice of law that still seem unresolved. It can do that, at least if it's properly understood, which I think it generally is not. Currie himself, I'm going to suggest, did not quite understand his insight, or at least not all of the implications of it. So, I'm going to start out by telling you very briefly the story of choice of law, or at least sort of the standard version of it. And we'll see where Currie's place is in that story, and we'll see a bit of the reaction to Currie. And then I'm going to go on, I'm going to talk about where we are now, where choice of law stands. So, spoiler alert, lots of people think choice of law is a mess. And I'm going to suggest that if we understand Currie's basic insight, the picture is not quite as gloomy as many people think. So, at that point, I'm going to tell you what I think the insight is. It is, I'm going to say, not about the outcome in particular cases, not really about how cases should be decided, but it's about the structure of the choice of law problem. It's about the different steps that a court must go through in deciding a choice of law question, and who has the power to give answers at those different steps. And having explained what I think is the deep insight, then I'm going to try to show you how it solves some problems. First, a couple of things I'm going to say Currie got wrong. And he got wrong because he didn't follow the logic of his own insight. Second, something he got right, that we didn't quite understand why. And third, how this insight applies to what the Supreme Court has been doing lately. Now, you might not know this, right? Even if you follow choice of law, you might not know this. The Supreme Court itself does not seem to know this. But I believe some of the cases the Supreme Court has been deciding recently are in fact choice of law cases. So a lot of people will tell you, oh, choice of law, it's sort of a backwater. The Supreme Court hasn't decided any choice of law case in a while. I'm going to say no, in fact. In recent years, it's decided a whole bunch. And then last, I'm going to try to say something about how this insight should make us feel about the state of choice of law more generally. So is it a mess, or are things perhaps a bit better than they appear? So first I said I was going to talk about the history of choice of law. Choice of law issues are going to arise anytime you have interactions between different legal regimes, or people governed by different legal regimes. So it's no surprise choice of law is actually one of the oldest fields of legal thought. If we wanted to, we could go back to Egypt, we could go back to Rome, but we're not going to. We're going to start with the early American approaches. So we're going to start with Joseph Story. Joseph Story wrote the commentaries on conflict of laws, a very important early work, something like a Restatement. How did Currie think choice of law problems should be resolved? His basic principle was comity. Comity, which means basically mutual respect between sovereigns. And he expected comity to be implemented primarily through the principle of territoriality. So if the courts of Georgia, for example, were hearing a case about a tort that occurred in Alabama, Story believed they should show respect for the state of Alabama and its laws by applying Alabama law to decide that case. After Story comes Joseph Beal. Beal takes this idea of comity and territorialism, but gives it a slightly harder metaphysical edge. So for Beal, territoriality, the idea that the state's laws have force within its borders, but not outside, territoriality is not a nice way to respect the authority of other states. Territoriality, Beal thinks, is mandatory, part of the nature of law. So Beal says things like law, by its very nature, applies to everything within a jurisdiction and nothing outside it. That actually makes choice of law pretty easy, right? To decide which law governs a particular transaction, all you need to do is figure out where that transaction happens. Then, Beal says, the law of that place will create rights, will vest those rights in the appropriate parties, which is why Beal's theory is often called the vested rights approach. And the final step for Beal, those rights will be transitory. That means you can take them into another state and you can sue on them. So for Beal, what's happening when the Georgia court hears a case about an Alabama tort, it really has no choice. Alabama law is the only law that can conceivably create rights relating to that tort, and Georgia courts must recognize those rights unless they have some very good reason not to. So, perhaps that sounds like sort of silly mumbo-jumbo to you, right? Things happen, rights magically appear, then you can put them in your suitcase and carry them somewhere else and pull them out and say, hey, court, look at these rights. Now give me a remedy. But before I ridicule it, I always like to point out, this is actually largely the way we still think about judgments. So, you know, you can get a judgment under one state's law, and you can take it into another state and demand that it be recognized. And in fact, you will have a constitutional right under the full faith and credit clause to say this judgment must be recognized when I take it into another state. But having said that, the Beal system is really actually still basically silly mumbo-jumbo. Because law is not by its nature territorial, at least not in any way that states are bound to respect. So back when people believed Beal, back when they were following his system, they also did think that the Due Process Clause of the Constitution placed limits, basically territorial limits, on state legislative jurisdiction, on the scope of state law. But they don't think that anymore. So Beal's theory, it works nicely for the most part if everyone accepts its metaphysical premises and acts in accordance with them, and for a while they did. So in a famous case, which I will discuss a little bit more later, you would see things like the Alabama Supreme Court discussing an Alabama tort statute and saying, this statute doesn't say anything about a territorial limitation, but of course we must read it as if it explicitly said it applies only to injuries received in this state. Why do we have to read it that way? Because asserting the legal authority to attach consequences to an injury occurring outside the state's borders, the court says, would be unprecedented and astounding. No one could imagine that this would happen. But then people do start imagining it. And once they stop believing that law must be territorial, once courts stop applying the Constitution to enforce this territorial limit, then Beal's system does start to look somewhat silly. The realization that it's silly historically is something that we generally associate with the legal realists, and probably in particular with Walter Wheeler Cook. So Cook, in Currie's words, discredited Joseph Beal's work as thoroughly as the intellect of one man can ever discredit the intellectual product of another. One aspect of Currie's greatness, most people agree, is his writing style. He's got all these zingers. If you think that's a zinger, which I do, I think that's devastating. Right? So the system starts to look silly. Why? Because it's this incredibly complicated system. You have to really read Joseph Beal's multi-thousand-page work to understand how complicated it is. But it's a very, very complicated system built on what turns out to be nothing. Or not really nothing, but jurisprudential assumptions that fell out of favor, that courts stopped enforcing, that people stopped believing. So it's a complicated philosophical edifice, sort of like Spinoza's system of ethics or logical positivism. And it's not surprising it ended up rejected. But rejecting Deal is one thing. Then you have the question, what do you replace it with? And the legal realists didn't really have an answer to that. They tended to say, oh, we should be practical and modern and realistic. But that's not actually that much guidance. But they didn't really have an answer. BrainerdCurrie did. So now we're going to slowly sneak up on Currie's answer. One reason that territorialism looks silly, I said, is it's this tremendously complicated system built on metaphysical premises that aren't true. But it also looks silly sometimes because it produces results that seem arbitrary in a certain set of cases. Alabama Great Southern Railroad against Carroll is a classic example of this. It's the one that my case book uses. I think other case books do too. And in this case, Mr. Carroll worked for the railroad. He was injured when a coupling came loose as he was riding on the train. So someone, a fellow employee, was negligent in inspecting the coupling. He was injured as a result of their negligence. Now, under the common law, this would create a problem for Carroll if he wanted to recover damages from his employer, the railroad, which he did. Because at common law, employers were not liable for injuries that one employee caused to another. This is what's called the fellow servant rule. Luckily for Carroll, Alabama had abrogated that rule by statute. So Alabama law says when an employee is injured by a fellow servant, the employer is still liable. But unluckily for Carroll, the injury occurred in Mississippi. And the place that the tort Joseph Beal's system prescribes is the place of injury. That's because injury is the last event necessary to make the tort complete. So the territorial system says the tort occurs in Mississippi, Mississippi law governs, and because Mississippi hadn't abrogated the fellow servant rule, Carroll can't recover. Now this is a wonderful case for illustrating the occasional perversity of the traditional approach, because the injury is really the only contact that Mississippi has with the case. So Mr. Carroll, he's from Alabama. The railroad is an Alabama corporation. He negotiates and executes his contract of employment in Alabama. The railroad lines are 90% within Alabama. They go just a tiny bit into Mississippi. The negligence that caused his injury, the evidence suggested, occurred in Alabama. So Mississippi's got nothing but the injury, and yet it's law control. And most people, if you ask them, will say, yeah, that does seem weird, regardless of what their intuitions about a sensible result are. So this seemed weird. It seemed perverse to many people, including some judges. And they began using various techniques to reach results that seemed more sensible. But once you start doing that, there's an obvious question that comes up. If you have these intuitions about what a sensible result is, and if you feel strongly enough about them that you're going to use these techniques, what people call escape devices, to reach them in particular cases, why not try to unpack those intuitions explicitly and come up with a system that actually advances them? And that's really where Currie comes in. So if you push people about their intuitions, what makes a result sensible, they tend to start talking about, if you suggest it at least, they tend to start talking about what states would want, what the states are trying to achieve with their laws, or the policies behind the state laws. And Currie said basically, let's give policy center stage. Let's be honest about what we're doing. Let's think about choice of law in terms of state policies. How do you do that? Well, he said, this is a matter of interpreting the laws at issue in order to determine whether applying them to a set of facts would further their purposes. If applying a law would further its purposes, then the state whose law we're considering is, in Currie's terminology, interested. So what does this mean? Well, in any case involving two states, now you've got three possibilities. You would have one state interested, both states interested, or neither state interested. If one state is interested, the case is what Currie called a false conflict. The solution is apply that state's law. If both states are interested, the case is a true conflict, and Currie said it really cannot be solved by courts. So since you can't solve the conflict, court should just apply its own law, apply forum law. Currie actually modified that view a little bit later, but the modifications are irrelevant to my points here, so I won't discuss them. So, false conflict, one state interested, both states interested, true conflict. If neither state is interested, now you have a bit of a puzzle. You still have to decide the case somehow, Currie believed. So again, just apply your own law, apply forum law. So forum law is basically the default choice, the presumption. If neither state is interested, it's called an unprovided for case. You have no reason to depart from the presumption of forum law, so that's what you apply. So that's Currie's sort of analytical framework. If you apply it to Carroll, what do we see? We see that Carroll is a false conflict. So first consider Alabama law. What is Alabama trying to do? It's trying to let some employees recover damages. Which employees? Well, presumably the ones with whose welfare Alabama is primarily concerned. That would be Alabama resident employees. Carroll is an Alabama resident, so Alabama is interested in allowing him to recover. Now what about Mississippi? Well, Mississippi wants to protect some employers from liability. Right? Mississippi law says some employers don't have to pay damages for fellow servant injuries. But which employers? Well, presumably the ones with whose welfare Mississippi is primarily concerned, which is to say Mississippi employers, or maybe employers doing a lot of business there. But the railroad is not a Mississippi corporation, doesn't do a lot of business in Mississippi. Currie would say Mississippi is not interested. So, false conflict, obviously Currie would say it should be decided under Alabama law, which is, you might notice, the sensible result. Right? Probably seems like a better outcome than the one that we reached under the territorial system. And in fact, the false conflict, the analysis I've just walked through, is generally considered the crowning glory of interest analysis. This is the approach at its most persuasive. Some people, in fact, would say that the discovery of false conflicts is Currie's great contribution. I would not. I would phrase it a little bit differently, as I will explain. But I do think that false conflicts generally make interest analysis look good. True conflicts and unprovided for cases, those are a little bit more problematic. I'll say a bit about them too later. But now I've said enough about Currie to start considering the reaction and the criticisms. So, first question. How should we characterize the analysis that I've just demonstrated? What is Currie's contribution here? Some people, I've noted, say it's just the discovery of the false conflict. I disagree with that. I think it's something much deeper. Some people say it's this idea of promoting state policies or of advancing government interests. And that, I think, is sort of right. It could be right, depending on what's meant by it. Some people, I think, took this idea very much the wrong way. That is, they took Currie to be saying that there are these things out there, objectively existing in some way, government interests, and the task of a court or a scholar is to figure out what they are and promote them, regardless of what the government that supposedly is creating them says or wants. So some scholars did say states can be mistaken about their own interests, and courts should advance those interests regardless of what the state wants. That, I think, is a mistaken idea. That I don't believe. A third way of describing Currie's insight, which you see, I think, most prominently in the work of Larry Kramer, is to say Currie realized that choice of law cases were not fundamentally different from other cases about the scope of state laws. They were not some esoteric procedural question to be decided before you got to the merits of the case. I think Aaron O'Hara, who gave this lecture last year, actually did say that that's what choice of law is. But that's not what choice of law is. Choice of law is about the substance of state law. And this is an ordinary question. It's the kind of question courts decide all the time. And choice of law questions should be resolved by the same tools as ordinary domestic cases. They're just questions of ordinary statutory interpretation. So this, I think, is the right way to characterize Currie's insight. And it is what Currie himself actually said. And in just a bit, I will try to explain where I think the insight leads. But I want to pause for a second here to acknowledge some criticisms, because there are some powerful criticisms, and in some ways I think the criticisms are correct. So the main one you see, if you read the scholarship, leveled most forcefully, I think, by Lee Brillmeyer, a bunch of articles starting in the 1980s, is that this process of identifying state interests is not statutory interpretation. What it is a process of creating state interests from a set of assumptions that actually don't correspond to actual legislative preferences or legislative intent. Currie, she famously said, was as metaphysical as Beagle. So, is that right? Well, in my discussion of the Carroll case, I suggested the legislatures of Alabama and Mississippi are trying to benefit certain individuals or certain entities. And then I said, and those individuals or entities are probably state domiciliaries, so Alabama workers or Mississippi employers. Now, what made me think that? You didn't rise up and object, but why did I say that? Well, it's a plausible assumption, right? It's a basic tenet of our political and constitutional theory. It's actually the basis for process theory. That legislatures look after the interests of those who have a voice in the political process. Alabama workers vote in Alabama elections, out-of-staters don't. So we would expect the Alabama legislature to promote the interests of Alabama workers more than the interests of out-of-state workers. Plausible assumption, but it is still an assumption. Right? Legislatures might care about other things too. They might care about Mississippi workers to the extent they can advance the interests of Mississippi workers. Or, probably more significant for choice of law, they might care about predictability. They might care about ease of application. They might want a simple rule. So, if they're guided by those systemic considerations, they might prefer a different scope to their statute, not the scope that helps out all the Alabama employees. Maybe even they would prefer a territorial scope, since that's a sort of nice and simple rule, generally. But interest analysis does not really consider that possibility. So, to some extent, the critics are right. This doesn't, the process I just walked through, doesn't really look like ordinary statutory interpretation. And there's actually another way of putting that, which I think is also a forceful criticism, though I think it's one that I came up with. But if you're thinking about ordinary interpretation, you've got a case that sort of falls on the margins of the statute, right? Does the statute cover this case or not? We're not sure. How do you decide it in the ordinary case? Well, typically, you'll look at the purpose of the statute. You'll ask, would application of the statute promote that purpose? This isn't the only approach to statutory interpretation, but it's probably the most common. So you have a statute, maybe it refers to pedestrians. You want to know, should you include people on roller skates, or pogo sticks, or something like that? How do you decide that? You would ask, why does this statute single out pedestrians? Are the rollerbladers or the pogo stick jumpers relevantly similar? So maybe it's about the speed at which they travel, right? And then people on rollerblades look different because they go much faster. Or maybe it's about contribution to air pollution. Now the rollerbladers look similar because they don't pollute the air. Maybe the statute is about something else. But whatever it is, there's some reason that the statute says pedestrians, and that reason is either going to apply to rollerbladers, pogo stick jumpers, or it's not. And interest analysis in choice of law is different. So with interest analysis, you've got people who really are indistinguishable. Right? A Mississippi employer and an Alabama employer could be identical railroads. They're indistinguishable except for their domicile, right? The state that they're in. And to figure out whether to treat them differently, we don't really look at the specific law and ask about the purposes of that law. We just assume that the laws exist for the benefits of locals and not out-of-staters. And we don't, in particular, as I said before, we don't ask whether the lawmaker might have been concerned about systemic values like predictability or ease of application. So it doesn't look quite like ordinary statutory interpretation in that way. But there are things to be said in Currie's defense as well. So first, Currie put forward this selfish state analysis, this idea that laws should be applied to benefit locals, as an assumption, and a deliberately oversimplified one, in order to demonstrate how the theory worked. It was actually not, if you read the article in which he puts it forward, it's not supposed to be a guide to conducting interest analysis in actual cases. Although, unfortunately, it ended up being taken that way, both by critics and by people applying interest analysis. But second, and most important, even if it's true that this is not ordinary statutory interpretation, it is still statutory interpretation. And this is what I think Currie's deep insight is. It is statutory interpretation because there's nothing else that it could be. So we have a state statute. we're trying to figure out to whom this statute grants rights and in what circumstances. And there is nothing that could be but a question of interpreting that statute, because there's nothing but the statute that has the power to answer that question. So Currie's fundamental insight, I would say, is about power. The first step in a choice of law analysis is figuring out the scope of the relevant laws, to whom they grant rights, and that's a question about the meaning of those laws. And a state, speaking through its legislature for a statute or its high court for a rule of common law, has the last word on the meaning of its laws. So that's what I take Currie's insight to be. The first step in a choice of law problem, determine the scope of the relevant state laws. This is what allows you to classify the case as a false conflict, a true conflict, or an unprovided for case. And the scope of state law is a question of state law. No one else has the power to determine. So, why is that an important insight? Well, first, it's going to tell us some things about how certain kinds of cases should come out. Some of these things Currie realized, some he didn't. I'm going to start with the ones he didn't. First, you might remember I said Currie recommended a presumption of forum law. If there's no sufficient reason to depart from the law of the forum, Currie believed courts should apply it. Now, that might make some sense if you're thinking about choice of law as a threshold procedural question, but it makes no sense if you think about it, as Currie saw that we should, as an issue about the scope of state law. We do not start out a process of statutory interpretation by assuming that a statute reaches every case, right? That doesn't make sense at all. So, presumption of forum law, that is wrong, according to Currie's insight. Second, Currie's analysis of the unprovided for case, where neither state is interested, that concluded with a similar prescription of forum law. The court should apply its own law, no reason to depart from this presumption. And again, this makes some sense if you think that choice of law is a threshold procedural issue that must be decided before a court can go on to this separate step of deciding the merits. You might think, well, the case has to be decided under some law, our analysis hasn't pointed us to any other state's law, so we're going to stick with forum law. But I've already said the presumption of forum law is a mistake. This resolution of the unprovided for case is mistaken for exactly the same reason. Choice of law is not procedural. Choice of law is about the merits. When you find that a case is unprovided for, what you found is neither state's law grants rights related to this transaction. Neither state gives the plaintiff a right to recover. And in that case, it makes no sense to say, therefore we will turn to forum law. This means the plaintiff has just failed to state a claim. So in fact, you cannot turn to forum law. Right? We've just said the laws at issue don't reach this case. That's why it's unprovided for. To then say, oh, but we're going to decide the case under forum law, is to give that law a scope that you've just said it doesn't have, in violation of the basic insight that the scope of state law is a question of the meaning of state law. And this is a point I'm going to say the Supreme Court has actually recognized in recent years. So those are two consequences that follow from Currie's insight, two consequences he didn't quite see. Now I'm going to turn to some that he did see, although not always perfectly. First, the easy one, the resolution of false conflicts. So what is a false conflict? According to the description that I've set out, it's a case where the events fall within the scope of only one law. Only one state's law attaches legal consequences to these events. Obviously then, the case must be decided under that law. It's the only conceivable law it could be decided under. To do otherwise is actually unconstitutional. This, I'm going to say, is something the Supreme Court has recognized. This is, in fact, one way of describing the famous case of Erie Railroad against Tompkins. Right? What is the constitutional basis for Erie? The Supreme Court says only Pennsylvania law reaches the events in this case. Therefore, for some constitutional reason, the case must be decided under Pennsylvania law. So there I say Currie was right, the Supreme Court agrees. Second, a little bit more complicated, the true conflict. What did Currie say about these? He said true conflicts cannot be resolved by courts. And I think that this is close to right. What Currie saw was that the question of how to resolve a true conflict cannot be answered decisively by any one state. So again, it's an insight about power. Who has the power to answer a particular question? And it's an insight about the difference between the two steps in the choice of law process. So first, Currie said, we need to figure out if there is a conflict. This first step is a matter of determining the scope of the relevant state laws. That's a question that's within the sole power of each state to answer in a way that is binding on everyone else. And sometimes this first step analysis is all we need. Right? If it's a false conflict, I said, you must apply the law of the only interested state. If it's an unprovided for case, I've said, the plaintiff just loses. It's not what Currie said, but it's the consequence of his theory, I think. But what if there's a true conflict? Well, now this is not a question about the meaning of either state's law. Right? We've looked at the meaning of those laws. We know they grant rights. We know the rights conflict. How do you resolve this conflict between the laws of two co-equal sovereigns? The answer is, no one can decide that authoritatively. Each state, presumably, can determine the outcome in its own courts, subject to some constitutional limitations maybe, but neither can bind the other. So Currie's insight, second insight, is at this second step, no state is authoritative. Each state is presumably free to decide for itself which law should get priority, and so too, I think, is a federal court exercising diversity jurisdiction. The last issue that this insight resolves, which Currie did see, although he said his conclusions were tentative, is the famous issue of renvoi. Some people call this renvoi. I tend to say renvoi because it sounds a little fancier. It's French, it's classy. But what is renvoi? Well, if you're not a choice of law enthusiast, this is probably not familiar to you. But it is one of the classic puzzles of choice of law. It's probably one of the things that make people think choice of law is so strange and esoteric. But it is the puzzle that arises when each state decides that another state's law applies. So we have a suit in Georgia, let's say. The Georgia court performs its choice of law analysis and says, this case should be governed by Alabama law. But now you might say, okay, good, we're going to do Alabama law. And we're going to start with Alabama choice of law rules. Right? Why not? That's what an Alabama court would do. And you might find in this case, Alabama choice of law rules would select Georgia law. So now it seems like you've got this endless cycle. Georgia law points us to Alabama law, but Alabama law points back to Georgia. And now, what will happen? Maybe the analysis will never end. Well, good news, it does end, right? Currie's basic insight resolves this problem very neatly. What's creating the problem here? What's creating the endless cycle? When do you get a renvoi issue? You get it when two states disagree about whose law applies to some case. Each state is saying two things. Each state is saying, my law doesn't, your law does. But remember Currie's first point about power. Each state is authoritative as to the scope of its own law, and not as to the scope of any other state's law. So, what's happening in this situation? Each state thinks its law does not apply. And that's right? It has to be. Each state has the exclusive power to set the scope of their own law. If they say, our law doesn't reach these facts, that's the right answer. Everyone has to follow that. Each state also thinks the other state's law applies. But there, they're both wrong. They're both wrong because they cannot, they simply lack the power to contradict another state about the scope of its law. So if you look at the renvoi puzzle, keeping in mind who has the power to answer these questions, the answer you get is neither state's law applies. Renvoi is just an unprovided for case. And that means, as I've said, plaintiff has failed to state a claim. So, those are what I think are some consequences of Currie's insight. And I think these are pretty significant consequences. They show us the right answer to some cases. They resolve one of the big, long-standing puzzles of choice of law. And everyone agrees Currie was an enormously important figure in choice of law. All the same, if you look at the current legal landscape, you might not think that Currie is doing all that well. So every year, there's a survey of choice of law approaches, and you can count up the states that follow different approaches. And there are only a couple of states, maybe two, that really follow classic interest analysis. The plurality, the big winner, is something called the second restatement, which is the most significant relationship approach. The second restatement certainly does incorporate some of Currie's insights, talks about policies in much the same way he did, but it's not, I think, faithful to Currie's deep insight because it does not set up the choice of law analysis as a two-step process. It says almost nothing about determining the scope of state laws. It seems to assume every state law has the maximum constitutionally permissible scope. So you've got lots and lots of conflicts, and then it tries to resolve those conflicts by asking which state has the most significant relationship. So some Currie in the second restatement, but not really as much as you would like, and not, I think, the best Currie insight. And then you've got some states that are still territorial. They do say a lot about scope, right? They say all state laws are territorial in scope. That's the rule that they follow. But they don't have much to say about resolving conflict. So you might think Currie's approach is really not winning. Different states have adopted a bunch of different approaches, and you might think this situation is a mess. People think it is problematic basically because it produces disuniformity. So different states follow different approaches. For the same case, for the same set of facts, you could file in Georgia and get one answer as to which law applies, or you could file in Alabama and get a different answer. And that, people think, is unfortunate. And I generally agree, right? It creates some practical problems if you can get different outcomes in different states. For a while, it looked like, in the heady days of the choice of law revolution, maybe the modern approaches would replace territorialism entirely, but it doesn't look like that's happening. It doesn't look like states are going to converge on a single approach. So, choice of law is a mess, you might think. Currie's true insight is being neglected, you might think. But now for the good news. The good news is there might not be a lot of courts that have followed Currie's insight. But here's one that has the United States Supreme Court. So you might not have heard that, as I said before. Even if you follow choice of law, you would not have heard that the Supreme Court has been following Currie's insight in choice of law cases, because no one else thinks that's what it's doing. But I think it is. And here's why. So what are these cases? The Supreme Court has had a bunch of cases recently about the extraterritorial application of American law. So application of US statutes, federal statutes, to events that occur at least partially outside the United States. And it has rendered some terrible and very confused decisions in some of these cases. And if you're familiar with choice of law, I'll just say Hartford Fire, it's a Souter opinion, but it's a terrible, terrible opinion. But more recently, the Supreme Court has been entirely in the Currie camp. So the question is confronted. Does a federal statute create a cause of action when some relevant events happen outside the United States? That is a choice of law question, right? That's just like the question in Carroll. Does he have a tort claim under Alabama law when the injury occurs in Mississippi? Now, the Supreme Court, it looks at these cases. It does not say, aha, this is a choice of law case. But what does it say? It says, this is a question of statutory interpretation. It's up to Congress what the scope of this law is. We're just interpreting the law that they wrote. And that, right, that is Currie's fundamental insight. Just a process of statutory interpretation. And in fact, I would say, the Supreme Court is more Currie than Currie himself. So what happens if the Supreme Court decides US law does not create a cause of action? And foreign law doesn't either, let's suppose, or at least no one has invoked foreign law. What do we have now within Currie's framework? We have an unprovided for case, right? Neither jurisdiction's law creates a cause of action. And what do we do with it? Well, Currie said, remember, decided under foreign law. But thinking about this in terms of the extraterritorial application of US law maybe makes clear how wrong-headed that is, right? If you've just decided the federal statute doesn't create a cause of action, you can't then say, well, but this case has to be decided under some law, so let's pretend it does, right? Let's apply federal law anyway. And the Supreme Court never did that. But lower federal courts and the Supreme Court in earlier cases did say, if US law doesn't create a cause of action, we dismiss for lack of subject matter jurisdiction. And that reflects kind of the same confusion that Currie had. You should think about this as saying, well, we can only decide cases under federal law, but federal law doesn't apply, so we can't decide the case. But in its most recent extraterritoriality case, a case called Morrison, the Supreme Court said no. What it means if we conclude that US law creates no cause of action is the plaintiff has no claim. The plaintiff loses. And that's exactly what I said Currie's insight leads us to in the unprovided for case. So the Supreme Court is saying this is not a preliminary jurisdictional issue. It's not a procedural thing. It's about the merits. Now, if you really are a choice of law enthusiast and you're familiar with Morrison, you might be shaking your head at this point. You might be saying, how can this be the victory of BrainerdCurrie? Because what the court says in Morrison when it gets to the merits is the Securities Act is territorial in scope. And territorialism, many people think, sort of the standard telling of the choice of law story, is anathema to interest analysis, anathema to BrainerdCurrie. It's the return of Joseph Beale. Larry Kramer actually wrote an article about how the Supreme Court's use of the presumption of territoriality with respect to federal statutes was the return of Joseph Beale. But I want to say it's actually not. What is territorialism, after all? It's just a rule of scope. Now, we know, it's Currie's basic insight, the legislature can give a statute whatever scope it wants. It could say this statute is territorial, and then, faithfully, courts will apply it only to cases arising in that state or that country. If the legislature doesn't say something explicitly, the court is going to decide what the scope of the statute will be as a process of statutory interpretation. Now, you could say territorialism is a bad rule of scope for the court to come up with, right? It's a stupid one. And Currie seemed to think that territorialism was not a great rule. But which rule of scope is preferable for sort of policy reasons? That's not Currie's deep insight. That's a wholly different question. Currie's deep insight is scope is a question within the power of the legislature. They can be territorial if they want to. If they don't give any explicit direction, a court might decide that territorialism is the best interpretation of their silence. So, Currie didn't offer this as an example, right? He offered the selfish state idea as an example instead. The scope of the statute should be whatever benefits locals the most. But that, remember, was supposed to be just an example. And if Currie had a blind spot, I would say it's his discounting of what we could call sort of systemic values, like simplicity, predictability, ease of application. If you've got a court that values those highly, or thinks the legislature values them highly, it might well think territorial scope is the best rule. Frequently, that will get most of the cases right. We'll have a small number of arbitrary results, but it's simple, it's predictable, it's easy to apply. So if you view its recent extraterritorial cases sympathetically, this is basically what the court is saying to Congress. It's saying, in the absence of any indication that you thought about this and wanted something different, we're going to prioritize systemic factors. We could do it differently, we could use the selfish state assumption, we could try to maximize some narrow understanding of American interests, but that's a bad idea in the international context because there are these sensitive questions about foreign relations. We're a court, we're not very good at that. We think, Congress, you're much more competent to assess diplomatic considerations. We're not going to step into that mess without your encouragement. That's sort of what the court says. It's close to what it says. And it's 100% consistent with Currie's insight. So the first bit of good news is the Supreme Court has adopted Currie's view. But that's on the international stage. It doesn't really affect state practice. Within the states, we still have this disuniformity approach. Time for the second bit of good news. Second bit of good news is disuniformity of approach is actually not that troubling. And it is not going to produce as much disuniformity of result as people think if we keep Currie's insight in mind. So this is what we should be doing going forward. But first, let me make a brief point about what we shouldn't do. Last year, again, you heard from Erin O'Hara. I don't know how many of you were here, but if you were here, or if you weren't here, she's great. Her lecture was great. But she's one of the people, along with Andrew Guzman, some other people, who are suggesting that choice of law should stop focusing on state interests and that choice of law cases should be decided in a way to maximize efficiency, regardless of what states want. And this is directly contrary to Currie's insight. So states have the power to set the scope of their laws, Currie says. Economists do not, even if they're really smart, even if they can figure out what's efficient. This idea that choice of law should now be guided by efficiency rather than policy is a terrible, terrible idea. It's a classic example of what I call economic imperialism, by which I mean the tendency of economic analysis, sometimes in the hands of its less sensitive practitioners, to just sort of impose itself ruthlessly on other fields of law without any consideration for their own inner logic. So, Currie's insight, I believe, tells us that prioritizing efficiency in that way is a bad idea. But it also tells us the current state of affairs is not so bad. And this is my main point. Disuniformity in choice of law, and the approaches that states follow, is not as bad as we think. Now, why is that? Well, what does this disuniformity amount to? Suppose that Georgia uses territoriality and Alabama uses, let's say, a selfish state version of interest analysis. That is, try to promote the interests of Alabama domiciliaries. Well, what are they disagreeing about here? Why do we get disuniformity of result? We get it because they're disagreeing about the scope of state laws. So Georgia, being territorialist, they say, Georgia law is territorial. And they say, so is the law of every other state. That's what you do when you follow a territorialist approach. And Alabama is saying, Alabama law reaches any case in which it might benefit a local. And so does every other state's law. Because again, if you're doing selfish state interest analysis, that's what you say about every state's law, not just your own. But this state of affairs should bring to mind our earlier discussion of renvoi. Because there too, we had states disagreeing about the scope of state laws. And that disagreement, remember, turned out not to be troubling. Because we knew each state is authoritative about the scope of its own law, but not about the scope of any other state's law. So the same point holds true here. Georgia can say Georgia law is territorial, but it cannot say Alabama law is territorial. It cannot say that about the law of any other state. And Alabama can say our law extends as the selfish state assumption dictates. But it can't say that about Georgia law. It can't say that about the law of any other state. That's what we conclude if we follow Currie's insight. So what does that mean? Well, we're going to get a situation, if we follow Currie's insight and sort of superimpose it on the current state of affairs. We get a situation in which all states agree about the scope of state laws, because they recognize each state law has one authoritative interpreter, which is that state and that state's courts. States are still going to follow different approaches to choice of law, but all that will mean is they've chosen a different scope for their own laws. And that's not a problem. In fact, this actually helps out people who are trying to do interest analysis. The main problem, remember, that the critics of interest analysis pointed out, and I said it was a good objection, is it's hard to figure out what a state wants the scope of its law to be, right? Do they want to try to benefit locals, or do they care about simplicity? We don't know, right? That's why this is a very unguided kind of statutory interpretation. That's why Currie said, to show you how this works, I'm going to use the selfish state assumption, and then couldn't really get much farther when he was trying to do it for real. But it turns out, states actually do say what they want the scope of their laws to be. They say it through their choice of law rules. So where does this leave us if we go forward this way? Well, what I'm suggesting here is a pretty substantial revision to current choice of law practice. Right? Under current practice, in defiance of Currie's insight, states regularly assert the authority to determine the scope of some other state's law, to say whether that law applies to a case or not, regardless of what the courts of that state would say. And I'm saying this is clearly wrong. I'm saying, in fact, this is unconstitutional under the full faith and credit clause, and it's something that Currie's teachings should lead states to stop doing. Will they stop doing it? Probably not. Not unless the Supreme Court makes them, and it probably won't. The Supreme Court is not interested in choice of law cases that it understands are choice of law cases. But sometimes, sometimes ideas do win on their merits. Sometimes they affect judicial practice. And choice of law is actually the area in which that has probably happened the most. Many people will tell you the influence of academics is actually the reason that the field is viewed as a conceptual disaster, but I'm a little more optimistic. So I think if states do follow Currie's insight, things will get simpler, things will get easier. All states are going to agree on the scope of state law, because they have to. This is Currie's insight, although he didn't quite see this consequence of it. Each state has the power to set the scope of its own law and to bind other states on that question. Now, states might not agree on priority, on how to resolve conflicts. This is also Currie's insight. No state has the power to bind any other on the question of which law should get priority in a conflict. I think, though, they actually will agree a fair amount. Right? I think if they understand the structure of choice of law analysis in this way, they will agree much more than they currently do. Maybe not all the time. Stronger constitutional limits, that might make them agree more. But there probably will be some persistent disuniformity. But that's not a cause for despair. I think that is just the price of federalism. So states differ as to their substantive visions of the good. They may also differ as to their visions of the best approach to resolving conflicts between their laws. If the conflicts prove too intractable, the federal government offers a way out. Congress could give us substantive uniformity on a particular question, could preempt state laws. It actually does that a fair amount, sometimes when there's a choice of law problem. Or it could resolve a particular choice of law problem through the full faith and credit clause. It could say, here's how this question must come out. It does that much less. It should do it more. Congress has other things on its mind, like shutting down the government. So we don't get a lot of choice of law legislation. But if Congress wanted to, it could actually prescribe a comprehensive choice of law code, a set of rules of priority that resolve all conflicts. And that would be, as far as choice of law is concerned, sort of the promised land. That would be total uniformity. That's the promised land. It's still a ways off. My claim here is just that Currie takes us farther in that direction than most people realize. Not all the way to the promised land of uniformity, but close enough to glimpse it. Currie, you could say, takes us up the mountain. Getting down, though, that is up to us.